You know, sometimes the biggest legal fights come down to the smallest details. Today, we're jumping into a case where literally everything hangs on the meaning of two simple words. It's a great story about rules, timing, and what happens when an organization, in this case an HOA, gets accused of not even following its own playbook.
So this really is the central question, isn't it? What happens when a homeowners association breaks its own rules? I mean, we all have to follow rules in our lives. But what happens when the people making the rules decide they don't have to follow them? Well, that's exactly what we're going to explore.
All right, so let's set the scene. Like a lot of these disputes, our story kicks off with one specific rule. A single sentence, really, buried in a community's official paperwork.
Okay, so we're heading to Scottsdale, Arizona. There's a community there, just 29 units, called the Hilton Casitas, and like you'd expect, it's run by an HOA. Now, this HOA has its own official rulebook called a declaration. You can basically think of this as the constitution for the entire community. It's a binding contract, not just for the homeowners, but for the board members too. Everybody's got to follow it.
And deep inside that declaration, we find the sentence that starts this whole mess. It's in section 17.1. It says, yeah, the board can hire a management company, but there's a big catch. They have to get prior approval from a majority of the homeowners. And those two words, prior approval, that's everything. It means exactly what it sounds like. The owners have to vote and say yes before any ink hits a contract.
Okay, so we've got the rule. Pretty clear, right? Well, now let's talk about what happened next, the thing that kicked this whole conflict off.
So back on October 9th, 2020, the HOA board does what boards do. They vote to hire a new management company. They sign the contract, and the new company is all set to start work on December 1st. On the surface, seems totally normal, right? Just a routine board decision.
But this is where things get interesting. Let's look at this timeline. The board signs that contract way back in October of 2020. Then, nothing. For over 2 years. Then, in December 2022, a homeowner finally says, hey, wait a minute, and files a formal petition. And get this, it's only after that petition is filed in January of 2023 that the board finally asks the homeowners to vote on the contract they signed years ago. See that massive gap? That's the heart of the problem.
And that huge delay, that's what sparks the legal challenge. You've got two sides with two completely different takes on what went down.
So on one side, you have the homeowner, a guy named R.L. Whitmer. His argument is super simple. The board broke the rules, period. They didn't get prior approval. Now, the HOA's defense was, well, a bit different. They basically said, look, the owners eventually approved it in 2023, so the whole thing is moot. It doesn't matter anymore. They even argued that continuing the case was just a big waste of everyone's money.
And you can hear the homeowner's frustration in his own words from the transcript. He said they're in breach of the contract, and to try to retroactively approve it doesn't cure the breach. I mean, he's basically saying you can't go back in time and fix a mistake like that. The rule was already broken.
So, you have both sides laid out. The case goes in front of an administrative law judge. It's time for a decision.
And the verdict? It was incredibly clear. The judge sided with the homeowner. Yep, the judge found that the HOA did in fact violate its own rules. And this wasn't just a slap on the wrist. There was a real consequence. While the judge decided not to hit them with a huge civil penalty, the HOA was ordered to pay the homeowner back for his $500 filing fee. It's a small amount, sure, but it's a very clear signal from the court. You broke the rule, and there's a price for that.
So you might be wondering, how did the judge come to this conclusion? Well, the reasoning is actually super straightforward, and it all circles back to that one little word, prior.
Okay, so first things first. The judge started with a really basic but crucial legal idea. And HOA's governing documents, the declaration, the bylaws, the whole shebang, they aren't just friendly suggestions. Nope, they are a legally binding contract between the HOA and every single member. That means everyone, including the board, is legally required to follow them.
And once you establish that, the rest of the logic just falls into place. It's like a domino effect. 1, the declaration is a contract. Okay. 2, when a contract uses plain language, you have to take the words at their most obvious meaning. You can't get creative. And 3, this is the big one. The plain, simple, unambiguous meaning of the word prior is before. That's it. So the judge's conclusion was pretty much inevitable. A vote that happens 2 years after a contract is signed can't possibly be prior approval. It's just not possible.
And here's the money quote, right from the judge's decision. It just lays it all out there, cutting through all the back and forth. The judge wrote that the vote in 2023 does not constitute prior approval of a contract that was entered into more than 2 years before the vote occurred. Boom. It's all about the timing. The way they did it made it impossible to actually follow their own rules.
So, what's the big takeaway here? Well, the main lesson is that process really, really matters. It's not just some bureaucratic technicality. The how and the when you do something can be every bit as important as the what you're doing. This whole case is a perfect example that following the agreed-upon rules isn't just a nice idea, it's absolutely essential for any organization that wants to be fair and transparent.
And that kind of brings us to a final thought, a question for you really. Think about any group you're a part of. Could be an HOA, a club, even a committee at work. Do you actually know what's in your rule book? Because as this story shows, you never know when one or two tiny words might end up making all the difference in the world.